All right, so we are talking about planning for the future. And I am Elena Sallitto. I am a certified elder law attorney. I am certified through the National Elder Law Foundation, which is a branch of the National Academy of Elder Law Attorneys. If you find that you need the services of an elder law attorney, the best place to look, quite honestly, is to get on NAELA's website, and AELA. You can search by zip code. Anybody who's a member of NAELA is pretty much dedicated to elder law issues. The designation of CELA, Certified Elder Law Attorney, we have demonstrated, we've taken a specialized bar exam, we've demonstrated a certain degree of experience and ability. So it's kind of, we've gone through some additional hoops that give us the ability to do that. So I would say look for a CELA, look also for a certified advanced practitioner, but definitely check on the NAELA website for anybody, for an elder law attorney if you are looking for one. That said, let's see, next slide. Okay, standard disclaimer real quick. This is just for general educational purposes anyway. Anything I say here, please don't take as gospel for your specific situation. Every client's fact pattern, every client's situation is unique. So don't take anything I say and say, oh yeah, Elena said, and then apply it to your own particular situation, and it may or may not work, but just so you're, just that's my standard caveat. So, all right, so advanced care planning. I'm going to start with what is an elder law attorney and when would I need one? Because this is pretty much of a basic question that everybody has. And probably the best definition I have ever found is this one. And it's that elder law is holistic and it's multidisciplinary, and it concentrates on the legal, financial, medical, social, and family issues affecting seniors, those with disabilities, and their families. And we are most often confused with estate planning lawyers, which are an entirely different animal. When you sit down with a purely estate planning attorney, because certainly elder law attorneys definitely do estate planning, but estate planning attorneys go, okay, what do you want to do with your stuff when you're gone? And we can do a will, we can do a trust. That's their focus. Elder law attorneys are more focused on that period of time when we kind of start to need additional services as we age. So as we need additional services to meet the challenges of aging, but before we are dead, it's that kind of that difficult, challenging part of life. That's where elder law attorneys come in. And we are holistic, we are multidisciplinary in that we are going to, we work a lot with geriatric care managers. I refer people to support groups. I send people to the Department of Aging all the time. We will work with your financial advisors, and we definitely want to know your family situation. So we will meet with families. We routinely have family meetings to talk about, mom and dad are getting older, or, I'm getting older, I want my kids involved. So it really does have that broad perspective where we kind of see what resources are available, how we can utilize everybody so that the senior, the person, whom we're concerned about gets the best possible quality of life that's available to them. So hopefully that's kind of an explanation of elder law. And, it's basically, you're going to need one anytime you're facing issues of long-term care. That's really where we do come in. So, I know typically these arise in a healthcare setting. Very often, you're going to have some kind of catastrophic health event that's going to land you in a hospital. From the hospital, you're going to go to a rehab facility. From the rehab facility, you're going to go to long-term care. Hopefully not, but if you do, and you're surrounded by the healthcare environment, the healthcare world. And the last thing on anybody's mind is, oh my God, I better call my lawyer. And that's the situation. And that's when you really do need to, make sure you do call your lawyer, because you're about to go into a situation that where your life savings are likely to be at risk. Healthcare is very expensive. Long-term care is expensive, and we'll go into that a little bit more as we go along.
Elena, so, we have a question here. Someone asked, how old do you have to be to use an elder care attorney?
Interesting question, because that's where I'm going right now. And that's, if we had a crystal ball, we would know exactly what we needed when we needed. But the answer, the fast answer is, if you're over 18, you need to have certain documents in place to make sure that your financial and healthcare needs are being addressed. So it's anybody over 18. And we also very much, most elder law attorneys, and our firm included, we do a lot with people with disabilities. So, if there is someone with a disability in the family, a son or daughter, a cousin, whatever, we would come into place then too. So it's basically anybody over 18. And as I go through this, it'll become very clear as to why. The fast answer is privacy regulations. So I'm going to go forward. And here we go. It's when to plan. And it really is, we are never too young to plan for possible long-term or short-term disabilities. And the reason is, we don't know what's going to happen tomorrow. And, one of the first cases I got involved in when I became an elder law attorney, it was just a horrendous tragedy. And it involved a gentleman in his mid-40s. And he had a young family. He had 3 small children. He had a lovely wife. And his wife really hated for him to play baseball on the weekends. So he snuck out, literally, this guy snuck out on a Saturday. He told his wife he was going to Home Depot or something. And he actually went out to play baseball with the guys. And he was the first baseman, I think. And you know where I'm going with the story, don't you? The guy at bat, and I'm not a baseball player, the guy at bat hit the ball and he just ran into first base, ran headlong into my client, who got knocked down, hit the back of his head, lost consciousness, and never regained consciousness. Of course, the guy's in his mid-40s. He's, up and coming in his career. He's got a young family. They had absolutely nothing in place. We ended up having to go to court for guardianship. We did Medicaid planning for them so we could preserve the assets for the use of the family. But, it was a nightmare. But, you never know. So, I tell my kids, in fact, I think one of my children does have powers of attorney in place. The other one does not. But, as soon as someone's over 18, they at least need to have powers of attorney. And I'll go through those documents and what they mean in a little more detail as we go down.
We have another question here.
Mm-hmm.
And I don't know if you're going to get to it in another part or not, but if I have a disability, will I still be able to get long-term care?
Yeah, absolutely. And there are so many different programs for people with disabilities and long-term care. It's there's a whole different agency that's involved, and it has to do with your age. And there are home-based, with government programs for either disabled persons or those that are older. And it's interesting. You are disabled until you're 65, and then after you're 65, you're old. So you still have access to the programs, but it's kind of like if you're over, under 65, you're disabled, over 65, you're aging. But yeah, there are programs. They do have their different eligibility guidelines in terms of, assets and income. But yeah, there are long-term care options available. So you're never too young, which is what I want to say. So whenever you're over 18, because of privacy regulations, nobody can take care of you unless you have these documents in place. It doesn't matter if you're married or single, or especially if you've got a diagnosis of a condition that may have long-term care implications. That is your big red light. That is run, don't walk. to your nearest elder law attorney, ideally, to get your documents in place so your loved ones can do the long-term planning for you to the, when they need to start moving assets. So, typically Alzheimer's, Parkinson's, if you've had a stroke, congestive heart failure, complications from diabetes. This is just an illustrative example. I'm sure the list is much, much longer. So I'm going to go ahead. And so what do we need to make sure that you guys are taken care of, that we're all taken care of? And there are really two main documents, and they are the financial power of attorney, and they are the healthcare advance directive. I put in the revocable living trust. Sorry, I'm watching my hands. I'm Italian. I tend to speak with my hands, which works in person, not so much on Zoom. A revocable living trust is not always appropriate for everyone, but people do have them. So the trust is also something that's going to have long-term care provisions in it that need to be coordinated with your financial power of attorney and your healthcare advance directive. So that's why I put it in there, but I don't want to spend a lot of time on the specifics of a revocable living trust. That's a different conversation. But the primary legal documents that you need are the financial power of attorney and the healthcare advance directive. Just an aside, I know I said I wasn't going to go into it, but I'm going to a little bit. If you have a revocable living trust, that trust dictates what happens only with those assets that are titled in the name of the trust. So a lot of times we see people that have trusts, but no assets were ever transferred into the trust. So the trust is basically, a very pretty document. Sometimes it's in a big binder, but it's totally irrelevant because all of the assets are still titled to people individually. And as long as your assets are in your own name, the trust it's irrelevant, has nothing to do with anything. So you've got your primary two documents, which is your financial power of attorney. And that's where you name the agent that's going to have access to pay your bills, do the strategic planning of your assets for long-term care. And then there's the healthcare advance directive. And that's the individual that's going to make healthcare decisions for you. And I'm really highlighting this. It's when you cannot make them for yourself. And, perhaps I should have highlighted a little bit more of, the decision-making, how it comes into place. With both the financial power of attorney and the healthcare advance directive, neither one of them strip your ability to make those decisions for you. You are always capable of making those decisions for yourself. The financial power of attorney, though, has someone appointed typically in addition to you. In the healthcare advance directive, you can appoint somebody that can help you, but you can't appoint someone to replace you unless you're incapable of making the decisions for yourself. So please feel free to ask questions on that. I'm hoping I made that clear, but I'm not sure that I did. So I want to talk about a little bit about appointing fiduciaries. And let's talk about first the financial fiduciary. Like I said, when you have a financial agent under a power of attorney, most typically that document becomes effective as soon as you sign it. And what you've done then is you've designated one or two or three or however many people that you trust, hopefully, that are going to stand in your shoes and manage your money on your behalf. And, when you're looking at these fiduciaries, both for healthcare and for finances, you really need to look at what are the skills that you're asking them to do, what are the tasks, and who's the audience. So with a financial power of attorney, these obviously are, geared toward, in terms of the audience, your financial institutions. So your audience is going to be your banks, your insurance companies, your stockbroker. That's primarily who your audience is. When you choose your fiduciary, you need to make sure that this person that you're about to appoint to take care of your money not only is trustworthy, hopefully they are, but are they good with money? I get a lot of people who say, well, I should be appointing my oldest child, even though he's declared bankruptcy 3 times, because I didn't want to make him feel bad. And, he's the oldest child and he's the boy, so he should be making the decisions. No, don't worry about anybody's feelings. You are really talking about somebody who's got to be good with money. Can they balance a checkbook? Are they late on their own bills? Are they on top of things? How are they with their taxes? You're not going to be giving the financial power of attorney agency to somebody with a gambling problem. In fact, that's just walked into my office today. I'm sure the child with the agency loves his mother, no doubt about it, but, he's got a problem. And it's just a little too tempting because he doesn't want to, anger his wife by using those assets. So it's just, real tempting to go to mom's money because, mom's got $500,000 or $600,000 in the bank, and mom's not really going to miss $50,000. And besides, I'm going to gamble it, and I am going to make all the money, and I'm not going to just give her back what I took. I'm going to give her 3 times as much as what I took. So, so you really have to pay attention to what you're doing with that and who you're appointing. Just because so somebody with a financial power of attorney, and I alluded to that, have the ability to kind of take all your money. They can. All they have to do is go to the bank. They present the document that says, I am the financial agent for mom or for dad or whoever it is. The bank manager takes it, they kick it upstairs to the attorneys vet it, they say, yeah, it's okay. This person has the authority to act on behalf of mom or dad. So to the bank, they have the ability to clear you out. They can write a check for the full amount of the money, for the full balance of the account, and they can put it in their own account, and the bank's not necessarily going to bat an eye. So they have the ability, but they do not have the authority. People who are fiduciaries, particularly when you've got financial fiduciaries, they have a legal responsibility to you of loyalty, of making sure that they act solely and exclusively in your best interest. They cannot self-deal. So if they are caught, they could go to jail. It's a criminal offense, it's theft. The other thing that a lot of them don't understand, especially when when you've appointed one child of many children to be the agent under a power of attorney, they have accounting obligations to not just to you but also to their siblings. Their siblings are potential heirs to your estate. Your siblings are also concerned with your welfare. And they're the ones that are going to be the most logical ones to make sure that anything that's being done with your money is being done honestly and correctly. So siblings have a right to find out what's going on with your money. So they have an absolute right to ask your agent to say, what's up? What are you doing? I want to see what's going on. So the agent has to turn over the accounts. This is what I'm doing. This is what came in. This is what went out. I spent it on mom or dad. And hopefully that works well. So that's with the financial agency. Any questions on that before I move to healthcare? 1, 2, I'm watching the.
Yeah, no questions are showing up yet.
Okay, good. Let's go to healthcare. On healthcare, they have to be your advocate. And this is what you want in a healthcare agent. You just, typically when we think about healthcare advocacy, who's named in the Healthcare Advance Directive, we're always thinking about the end of life thing. Who's the one who's going to say, yeah, pull the plug on mom or dad? No, that's not where it really becomes important, at least in my mind. It's really important for healthcare. You want your person to be your health advocate. You want that person to be by your side as you go through the healthcare process. So you want them to be at the hospital. You want to make sure that when you go from the hospital to the rehab facility, that your meds are correct. You want the person to be there at your bedside to say, oh my God, mom's hurting. Where the hell is the nurse? It's time for their meds. You also want that person to be able to push back against the medical establishment so they advocate for what you want and what you need. A good example that I have is I was the healthcare advocate for my dad. And God bless my dad. He was very vocal with me about what he wanted and what he did want at the end of his life. So he really did leave me guilt-free, which is, the criteria that I always recommend to my clients. Make sure your healthcare advocate is guilt-free. Don't leave them guessing. Make sure they know exactly what you want. Because your healthcare advocate is supposed to make decisions on your behalf that they know you would make for yourself, not what they would want for you, but what they know you would make for yourself. So just, to illustrate, I had a situation with my dad. This was toward the end of his life. He had congestive heart failure. I don't know if anybody's familiar with it, but, very often with congestive heart failure, your body fills up with fluid and it starts to collect in your legs. And your legs become very big, very bulky, very difficult to move. And my dad's doctor, went to, talk to my dad and said, you really need to go into the hospital. I want you there. I want to do, diuretics on steroids. I want to make sure we get this fluid out. It's very dangerous for you not to have it. And he said, no, I'm absolutely not going. What she didn't know was, over the previous year, my dad and I had constant conversations about what he wanted and what he didn't want. And he was absolutely adamant. I don't want anything invasive. I don't want to go to the hospital. He was a strong Sicilian man, and he made it really clear what he wanted and what he didn't want. So, the doctor, poor doctor, saying, Dominic, you got to go to the hospital. You have to. And he's going, I'm not going. So this poor woman turns to me and says, Elena, talk to him. Tell him he's got to go. And I just looked at her and said, no, he doesn't want to go. He's not going. And she was a little appalled and a little upset, but, she went off on her merry way. And I'm happy to report that, the happy ending to the story is, he didn't go to the hospital, because what I said to the doctor was, you're going to take him there, you're going to rotor him, you're going to get the excess fluid out, you're going to send him back to, he was in assisted living at the time, you're going to send him back to assisted living, his legs are going to grow up again, you're going to go back to the hospital. He doesn't want to spend his last life, his last months like this. So that's what I explained to her, and she didn't buy it. But so the happy ending was he did not go to the hospital. The swelling went down on their own. His legs got back to normal. No diuretics, no hospitalization. It was amazing. And he was there probably another 5 or 6 months before he died, very peacefully, very quietly, and very happily in his own bed. And he was spared the back and forth. But, I had to push back against the healthcare, the healthcare machine. But my dad gave me the ammunition to do it, and to do it comfortably. So,
Elena, we have another question here. So if someone does not have children and other blood relatives are not suitable, are lawyers or other professionals available to be appointed for these issues?
I hate to say it, if they're few and far between. For financial purposes, absolutely. Everybody's, that's easy. When you get into the healthcare advocacy, it gets a little more difficult. And you've got to find, in my experience, and Mary, you may have something different, but in my experience, the geriatric care managers don't do that. They really don't like to get involved in that. I have served as healthcare agent, and my firm serves as healthcare agent for several people. And the way we've done it, it's worked out very well. I'm the agent, I'm the one that gets the phone call, but I'm not a clinician. So I would bring a geriatric care manager on board, and we will have, a caregiver, someone who's there with the client, who knows this person, on an intimate level. And while I am, the ultimate decision maker, I don't make that decision alone. I do it in conjunction with clinicians who don't want the responsibility of making the decision, but they're there and they really know what the person is about. And so, that's how we've handled it. we've also, when we have that situation with, and I think people refer to people in that situation as, quote, orphaned adults. What I like to do is set up a support team. Obviously, while the person is still very much alive and participating in their decisions, where we have, myself and the care manager and the caregiver and the financial advisor and, the head of the assisted living unit, anybody and everybody who has a say in the care of this person, and have regular meetings to make sure that the person's wishes are being fulfilled and that they're being taken care of. That was a very long-winded answer, and I hope I did answer the question.
And I just want to throw out too, I have known of a few people who have used a close friend. So if there's a close friend who you trust and who is willing to take on that role, I have known a few people who have done that.
Ideally, you want somebody, especially for healthcare, you want someone who knows you. Somebody who understands your values and your wishes, and the one who's going to stand up for you. So that's really the criteria. And, if you don't have that person, yes, there are people that are willing to step in, and they will make every effort to make it as comfortable and as appropriate as possible. But close friends, absolutely. All right, the last thing I do want to say in terms of appointing fiduciaries is please, please, please choose one person. I know just one person. Put successors down, absolutely. But if you can, just choose one decision maker. And this is why. And again, it's, we're talking about the audience for these documents. For financial, we're talking about the financial institution. For healthcare, we're talking about the doctors. And they need to know who to talk to when there's a decision to be made, especially in healthcare. I'm involved right now in probably one of the most contentious guardianship cases I have ever been involved in. And it involves, mom who appointed all three daughters as equal decision makers, and took great pains in saying all three of my children are to make decisions together, jointly. And the problem is the three daughters can't agree on what day of the week it is. So, we're having arguments over, mom's legs need to be up. Well, how long do they need to be up? The doctor said this. No, the doctor said that. I want them up 20 minutes. No, it's supposed to be every, it's the most insane thing I've ever been through. And we're in a very hotly contested guardianship case. And we are now looking at legal fees of in excess of $50,000. So, please just one primary person. And then have successors so you avoid this. I think I'm actually seeing the chat. I know there's another. Okay. Should I move on?
Sure. Yeah. I think she was just sharing that, her uncle has three people actually as part of his team.
Okay. Oh, okay. All right. So this kind of segues into this next slide, which is guardianship. So what happens if either you don't have someone, you haven't appointed someone, or you've appointed three daughters who can't agree on what day of the week it is to be your decision makers. And that's when we get into guardianship. And guardianship is going to the court and saying that there is a vulnerable person, that they are vulnerable in terms of their property, that there's no one there who's able to, manage their finances because there's no financial power of attorney. And there's nobody there to really make healthcare decisions for them because either there's nobody available or because of the person or persons that are appointed can't agree, or the other way this can happen is the person that has been appointed under either a financial power of attorney or a healthcare power of attorney is not doing a really good job. In fact, they're harming mom or dad. There's financial exploitation. I wish I could say it's rare, but it's not. there's abuse, there's neglect. So you need the court to step in and get some order to make sure that this person is actually protected. So when you do a guardianship proceeding, the court is actually the guardian, and what we call the people we call our guardians are actually just agents of the court. And once you go down this road, the court becomes part of your family for the rest of this person's life. It's an expensive, lengthy proceeding in Anne Arundel County right now. I think it takes, for an uncontested guardianship, somewhere between 4 and 6 months. And it will run probably $3,000 for the petitioner, another $1,500 for the court-appointed attorney. So you're looking at around $4,000 or $5,000 for a guardianship. Whereas if you did the powers of attorney for a few $100s, you would avoid this guardianship. So what happens typically with a guardianship, just walk you through it real quick. Somebody elects to be the petitioner. Somebody goes to the court and says, you know, this vulnerable adult needs help. They go in with 2 medical certificates and they file their petition. The court looks at what they filed and says, yeah, okay, we think there may be a problem here. They appoint an attorney to represent the alleged disabled. And we notify, you know, all of the family members, everybody who is what's called an interested person. We also you also notify anybody any government agency that has an interest in it. So you might be notifying Social Security, you might be notifying the federal government in case of a federal pension. If the person is over 65, you're going to be notifying the Department of Aging. If they're under 65, you're going to be notifying the Department of Social Services. And they follow what's going on because they are an interested person. If there is no one available to serve as guardian of the person, then you're going to get the county. The public guardian is going to be appointed to take care of that person. And in our case, the public guardian is a very lovely lady, somebody I love very much. And I think she's got a couple of people working for her now. And they take care of them. They visit everybody at least once a month, and they are there to make these decisions for them. And for guardian, the guardian of the property, if there's no family member, then what the court will do is appoint an attorney in the community. And that attorney will step in and take over the finances. So it's if it's a contested hearing, like I said, I alluded to this crazy case that I'm involved in, where fees are running like $50,000. It's very unusual. It will be something less, but you know, still, that's a lot of money. Are there any questions?
Yes, Elena. Now this kind of goes back to the slide before when you were talking about the financial fiduciary. So what information does the financial appointee need before the need arises? So what do we need to tell the person that we're naming? What kind of information do they need ahead of time?
That's a question. That's a really good question. You know, what I suggest to my clients is that they talk to their potential fiduciaries to see if they're willing to do this, because quite honestly, it's a thankless task, you know, especially if you're a child and you're being called on to take care of mom or dad's money, and you may have a couple of siblings out there that are going, what the heck are you doing? And, you know, people who are not that concerned about mom or dad's care necessarily, but they really want to know what's going on with their potential inheritance. To the extent that you can, if you're organized, and I for one am not, you want to give them where your accounts are, the account numbers. I would give them, put passcodes, access codes, whatever that is, put that somewhere in a centralized location so that, your fiduciary can find that information easily. I wish I was that organized. I'm not. God help my children if they ever need to step in and take care of me, and they will probably curse me until the day I ultimately die. But
I'm going to jump in here for a minute, Elena, and just for folks that weren't on a workshop that we did a few months ago, and I shared information about the vital documents folder. can't see it too well here, but this is something we have at the Department of Aging and Disability. So it's a folder, but on the inside, you can list that information that Elena was just talking about. You can list, put down account numbers, passcodes, where they can find things, you know, where they can find if you have a safety deposit box, where the key is, things like that. So I offered a few months ago for folks, if you wanted a copy of this, we're willing to mail that out to you. Just make sure you send me an email. Tell me, you know, how many copies you need, and I'll get that out in the mail to you. But that will help keep you organized, that information that Elena is just talking about.
I've seen what you're talking about, and it's fabulous. I absolutely love it. In fact, I think I was at one place where I stole a bunch of them, and I gave them out to my clients, and I ran out. And I'll probably go and grab a few more. It's really good. It lays it out very clearly. This is what I own. This is where it is. These are the people. You just want something in a centralized location. Another thing I want to say about too, the various documents, you know, with the Healthcare Advance Directive, where you're appointing the person who's making healthcare decisions for you, you want to distribute that far and wide. You give that to every healthcare provider. You give it to your agents. You every time, if you have to go to a hospital, you give it, you bring it with you to the hospital. It goes with you to rehab. That document is spread far and wide. Give it to your neighbors, give it to whoever. And in fact, there is a company that lets you put it in the cloud, but I don't think the hospitals are quite connected there. So that might be a little premature, but that feel free to distribute. The financial power of attorney, not so much. What I tell people to do is pretty much keep it in a safe place. Let your agents know that they are agents, but don't necessarily give them the documents, because what they're going to have to do, if they need to exercise their authority under the financial power of attorney, they're going to have to go with the original document. They're going to have to go to the bank and say, here I am, I'm the agent under the power of attorney. The bank's going to want the original. They're not going to keep the original, but they're going to take it, they're going to make a copy, and then they will give the original back to the agent. You are giving your agent the absolute immediate authority to access your bank accounts, to access all your financial records. You may not want that unless you absolutely need them to do that. So just let them know that, look, you know, if the need arises, this is where it is. But, you know, anyway, for my healthcare, you're the agent, you know, here's your copy, here's your document. If you need to go to the hospital to talk to anybody on my behalf, bring this with you. So just be mindful.
Question for you. Does the healthcare directive have to be notarized?
No, it does not. The Healthcare Advance Directive only needs to be witnessed by two people, one of whom cannot profit from your death. It cannot be witnessed by the agent, but it can be witnessed by, by one child, so to speak. And then let's say one neighbor, but just has to be witnessed by two people. The financial power of attorney must be notarized and have two witnesses. For healthcare powers of attorney, they're available everywhere. You don't need a lawyer. Download them. The Attorney General's website, if you get onto Brian Frosch's website, he's got the advance directive, download it, have a party with your friends, everybody fills it out. It's a great thing. Please, with the financial power of attorney, people tend to download them. Do not do that. They are, if you're going to be doing any kind of long-term care planning, they're not, it's not enough. They're insufficient. They're statutory, so they meet basic minimum requirements. But if long-term care planning is in your future, it's not going to fit the bill. So you will end up being penny wise, pound foolish, and you're going to end up needing some kind of guardianship proceeding down the road. So please, it's a few $100s. It's really well worth the money to go to a reputable elder law attorney. Don't just go to an estate planner, go to an elder law attorney, say long-term care might be an issue, and I need to have these documents done correctly. And just so you know, what we tend to put in these documents are the ability to create what's called special needs trusts, because we use them a lot. These are trusts specifically for people with disabilities, where we can put money into the trusts and it doesn't disqualify them or jeopardize their government benefits. We use gifting strategies a lot to keep some of the money available for the adult who's in a nursing home. So you need to have that gifting authority in the document, and it's not in the statutory form. You have to add it into the statutory form. So those are just two things that, right off the bat, I know need to be put in there. There are others as well, and they're very individualized. So, that's my speech with it. Please, please, please don't just download it off the internet, sign it, and think you're done. You're not. You're inviting a guardianship down the road.
Okay, so two things, Elena. One is, if anybody needs the Maryland Advanced Directive form, I can also get that mailed out to you or email you the link, one or the other. And we have another question. So someone asked, and I believe this is going back to the guardianship. If someone is appointed the financial attorney, is there an agency to oversee accountability of the person or persons named as financial attorney?
Okay, so you're talking about financial power of attorney, the attorney in fact. No, there's not an agency, but there are statutory provisions that let certain classes of people demand immediate accounting access, or go to court and require and demand that access. The people that are authorized to go to court is a much broader class of people than the people that can just ask for it and expect to have it done. And I think it's because, there's a sense of, a certain degree of privacy, in terms of the financial the financial power of attorney. So there's no government oversight, but there is court oversight. The other thing that you can do too, is if you think somebody is abusing a financial power of attorney, if you really have some good information, not just you think you don't like him, your brother's always been a real schmoo, but you really think that he might be doing something, you can call the Adult Protective Services. They are basically the police, and they will do an investigation to see if money is being mismanaged or if the elder is being abused or neglected in some way. So, that's something else. And that's a police investigation that may or may not end up in a criminal investigation of criminal charges. So that's there. All right, I'm going to continue. I think where's my thing here? All right, long-term care. This is where we spend a lot of our time. And, I know you're all caregivers, so I'm assuming that you're here because somebody's got some kind of diagnosis with something that requires some kind of care. And I imagine everybody already knows that this is not a fun place to be. We as a country don't do this very well. It is not covered by health insurance. And where the confusion lies is that Medicare will pick up to 100 days of rehab following a stay in a hospital for 3 midnights as an inpatient during non-COVID times. So we're going to be going back to that soon, I think. But as soon as you segue from that rehab, which is curative, which is supposed to be short-term, if you go beyond that, where it becomes clear that, the patient isn't going to really be able to go home, or the patient, needs some kind of services to maintain their safety, you're looking at long-term care, and health insurance is not going to be involved. So Medicare is not there for you. Blue Cross is not there for you. What happens? And, we get people in our office a lot. They'll call up and say, okay, mom or dad is at XYZ skilled nursing facility. They've been on rehab. We've just been told Medicare is running out next Thursday, and we're not sure what we're doing. They're going to discharge mom or dad. So let me start by saying, I don't know if there are any hospitals here, but no, or any nursing homes. If you get that, no. They cannot discharge to something other than a safe environment And if you don't have the ability to care for the person at home safely, you say no. So don't let anyone, any healthcare provider, push you or push you into getting into what you know is an unsafe situation. If you can't safely take care of this person, whether it's mom or dad or husband or wife, just say no, this is not going to work. We have to find some kind of alternative arrangement. So they cannot discharge. That's not to say if Medicare doesn't cover it, there are going to be long-term care charges. So that's like part B in this whole scenario. But right now, you know, if somebody's saying we're discharging tomorrow, you got to take them. If you don't have a safe place for them to go, you do not have to take them. So do not let them bully you into doing something that you know is unsafe. So let's go into long-term care because it is not covered by health insurance. So even after you say, no, I'm not going to take them home, they got to be somewhere. Somebody's got to pay for their care. So long-term care is expensive, and it's not covered by health insurance. So home care, this is my experience. Mary, if you have any other information, please chime in. Typically, if you're going to go through an agency, it's about $25 an hour with a 4-hour-a-day minimum. So, you know, if you only need a couple of days a week, it's not so bad. As you're starting to need, you know, 8 hours a day, 12 hours a day, 24 hours a day, it can get really, really prohibitively expensive. Assisted living. These are average figures that I've seen in the community. It can be as low as $4,000, and it can go, I think this is kind of a little extreme, but I did call one assisted living facility, a very well-known one in the area, because I needed to get some, some financial information from them. And I pushed them. I said, okay, worst case scenario, they need absolutely everything. What's the worst case? And they said, yeah, it could be up to $15,000 a month. So that's definitely on the high side. That's definitely on the extreme side. But know that if you're in an assisted living facility, you're looking at somewhere between $4,000 and $15,000 a month, and it's not covered by insurance. Nursing home care, from what I'm seeing, is about $14,500 a month and up. And government assistance, Medicaid, is available only for long-term care in a nursing home. So, I mean, you just look at the cost and you know it's prohibitive. So I'm going to move on. I keep losing my cursor here. There we go. So government assistance, Medicaid, pays for long-term care in a nursing home. If you're going to go that route, your person, the applicant, needs to be both medically and financially eligible, meaning the applicant has to be sick enough to require nursing home care. That means that they need hands-on assistance with 2 or more activities of daily living, or they need supervisory assistance with, I think, 3 or more activities of daily living, and assistance with, I think, 2 or more instrumental activities of daily living if they have cognitive deficits. So I just know that they are sick enough, they need to be sick enough to need nursing home care. The applicant can have no more than $2,500 in countable resources. The applicant's spouse, if there is one, can keep half the marital assets, and they measure that on the first day of the first month in which the applicant goes into long-term care, whether it starts off in a hospital or goes right to skilled nursing. Half the marital assets with a floor of $26,000 and a ceiling of $130,000. So you're looking at combined assets between the spouse and the applicant of $26,000 plus $2,500 with a ceiling of $130,000 plus the $2,500. And everything over and above that has to be, I call it, restructured. There is a 5-year look back, which means that the state will look back 5 years at all of the couple's assets, meaning every single bank account. And they will look at every bank account and every transaction in every bank account to see if there have been any transfers made for, quote, less than fair market value. And to the extent that there are those transfers for less than fair market value, the state will penalize the applicant of 1 month of services, 1 month of nursing home services, for every $10,000 that has been given away. which means that they find you eligible. You know, let's say what we're coming up to, the month of May is gone. If we're looking for eligibility now, we are looking for June 1st. We would do a spend down, we would make you eligible. You've got some kind of transfer of assets. And the government says, okay, as of June 1, yeah, you're eligible, you would have been eligible, you are eligible, you meet the criteria, but you gave away $100,000 3 years ago, therefore we are putting in, incurring a 10-month penalty. So for 10 months, we are not going to cover services. So that's what that means. And there are ways to cure it. And that's, let's see, yeah, I don't think I went into it, but yeah, there are ways to cure that. So you actually cut that back and are able to keep some of the money back for the, for the care of the applicant. If you have excess resources or if you have a penalty, excess resources, what we do as elder law attorneys is we will tailor the spend down of those excess resources in a way that's going to protect the applicant and their family. Nursing homes offer to help you with Medicaid eligibility. Nursing homes are not financial advisors. Nursing homes cannot go through this list and other lists that are able to do the financial planning that will protect your family and you. They're going to say, those are the, they're just going to go back and say, okay, you can have no more than 26,000, minimum, 130,000 maximum. The applicant can have no more than 2,500 in countable resources. If you're over that in, either one, there's no eligibility. So that, that's pretty much all they can do. Where as an attorney, we are able to help you restructure. We work with your financial advisors, we'll work with your accountants, we will restructure the assets in a way that we achieve eligibility and still protect those assets. So we will do allowable asset transfers. We will say, okay, debt reduction, obviously, we're trying to get rid of some excess money. Is there credit card debt? Is there anything that should be spent down so that the monthly nut that's left with the spouse that's still in the community is manageable for them, because they are going to lose, most likely, a portion of their household income, because part of the household income is about to go with the applicant to cover their cost of care. We do special needs trusts a lot, and these are a special type of trust that are there for people with disabilities, where we actually encourage. The state of Maryland is great about it. The state of Maryland says we love these trusts. We like, we want to use these trusts. So you are able to put money into a special needs trust for the benefit of somebody with a disability, and it doesn't impair the eligibility of either the person who's giving the money or the person who's getting the money. Single premium immediate annuities is something we use a lot in marriage, in spouse situations. We are able to actually transform any excess resources from being a resource. We transform it into an income stream. It's an annuity for the benefit of the spouse that's still in the house. The spouse in the house. I actually had a client call it. I said the community spouse. It's like, oh, you mean the spouse in the house? So it's a little bit of Dr. Seuss there, but yeah, for the spouse in the house. So so the state says, the government says you can have no more than $130,000 in resources. Well, we've taken some of the excess, we've taken it out of the resource camp and we turn it into an income stream. So it's no longer countable. It's paid back over a very short period of time, and it's paid back to the community spouse. So the community spouse is actually able to keep the lifelong savings of the couple, albeit in a different structure, a different format. So that's what we're able to do with that. We can purchase excluded resources. So investment properties, income producing properties. What I'm trying to say is there are a whole host of tools that are available when you do the Medicaid planning so that you protect the assets for the use of the family, especially the community spouse or the person that's getting the benefits, without just impoverishing everybody by giving everything to the nursing home for the care. You don't have to do that. And in fact, I think it's really counterproductive to do that, especially where you've got a married couple, because what you don't want to do is use all the money to pay for the person who's in the nursing home to the point where you impoverish the person who's home and they're left really hurting. Because honestly, $130,000 is not a lot of money, especially if you've got a younger spouse and they're trying to live on Social Security. And the average Social Security check is what, like $1,400 a month? So, you try living on $1,400 a month with $130,000, that's it in your bank account. And you're supposed to be like moving on with life and living the rest of your life. You don't have to do it that way. There are lots of other ways to do it. So you're protecting your assets for yourself.
Elena, we have 2 questions here. Is this good
Okay.
time? So first one is the look back review based only on bank account records?
No, it's everything and anything. If you've given away a house, they're going to want to know about it. If you give away, it's any asset transferred for less than fair market value for the purpose of qualifying for Medicaid. That's the other piece, for the purpose of qualifying for Medicaid. And there are lots of times, life happens and families are there to protect each other. I had one situation where, my God, one of the sons had gotten involved in some horrendous legal situation. It was really awful, with potential criminal charges. The guy lost his job. It was really, really awful. And mom, being mom, just started, giving this guy money. Here's money for you. I'm going to pay for your lawyer. I'm going to take care of everything for you. Don't worry about it. It was like 3.5, 4 years later, dad is applying for Medicaid. Had we not been there to say, yeah, but this is why, this is what happened, and it falls under this exemption or this exclusion, they would have been penalized for that. But we did an affidavit. We said this is not, they didn't do it for the purpose of qualifying for Medicaid. They did it to protect their son. And, it passed muster and it was fine. So.
And second question is, what happens when the couple is not married, but bank accounts are in both names?
You're not married. You've got to be married for the spousal protections and the spousal impoverishment to work, unfortunately. Joint assets it depends. It's a little tough because you've got joint assets that you would have to establish, I think, who owns what. You would have to establish when the particular account was, established as a joint account, whose money is in the account, and then you have to divide it up like that. So it's a lot more bookkeeping, but no, the application would be as a single person because you're not married. The state doesn't recognize domestic partnerships for purposes of Medicaid, unfortunately.
Okay, that was it on questions.
Okay, is that it?
Yep. Yeah.
Okay. I want to talk a little bit about post-eligibility estate planning. And that's something that absolutely needs to be done when you've got a married couple. Because what you don't want to have happen is and this does every so often, the spouse in the institution outlives the spouse in the community. What we do when we do the Medicaid planning is we basically do impoverish the person that's in the nursing home by putting all the money in the community's name in some way, shape, or form. The last thing you want to have happen is for the community spouse who owns everything to predecease the spouse in the institution and then have the spouse in the institution inherit everything. And all of a sudden, the spouse in the institution now has a chunk of money. He's no longer under the $2,500 in assets. He's way over, and you have to do the spend down all over again. You don't want to do that. So there's estate planning that we do that, in terms of wills, the establishment of trusts. The laws just changed with now a 2-year clawback of money that's been transferred 2 years prior to the person's death. It's just gotten really crazy. But we do that post-eligibility estate planning that makes sure that everything that we've done to make sure that the spouse in the institution stays on benefits, and that any money that would have been left to the spouse is left to them through a special needs trust, so that it goes into this trust that's available to supplement, not supplant, his government benefits. So he's able to get transportation out of the nursing home to go visit family, be part of the birthday parties. He can have his Alexa, he can have massages, he can have Reiki, he can have all of these wonderful things, a private duty nurse. All of that would get paid for by the special needs trust. And at his death, I keep saying his, I'm sorry for all the men in the audience, at the institutionalized spouse's death, then anything that's left over actually would go to heirs. So, so there are lots of ways to really make sure that the family is taken care of, and that you're not impoverished, and you don't have to live a life of destitution simply because, somebody in the family needs long-term care services. I so wish we did this differently. The legal term for how this country handles long-term care is we suck. It's awful. I wish we could do it differently, and certainly everybody's looking for ways to do it differently. But for now, this is what we got, and this is what we have to deal with. I'd like to see us change they're called waiver programs, where the government waives the requirement that long-term care services would be provided in a nursing home and lets us take them home. I'd like to see us expand that. We're working on trying to get the state to enhance the waiver program instead of cutting it back, which seems to be what they're doing right now. And just have people have more options as to where they're going to get long-term care. In my ideal world, you stay home, you're surrounded by family and friends. It's not just good for you, it's good for your family, because I grew up in a multi-generational house, and I'll tell you what I got from my grandmother, I could never, ever, ever get that anywhere else. And I think putting people in nursing homes, isolating them, taking them away from us is a real crime. It's a real tragedy. And I'd really like to see us change that. Anyway, I didn't mean to end on such a sober note, but that's kind of how I went. I apologize. I'm just down to questions. Hopefully somebody's got a little more uplifting question, because I kind of ended. Oh God, I hope I'm not, Debbie Downer here.
I think a lot of folks were asking questions as they went along while it was fresh in their mind.
Okay. All right. Well, I hope I gave everybody some good information. I invite you, if you have any questions, you want to follow up, please feel free to get hold of me. Can I go back and kind of give everybody, let's see.
Good.
Yeah, we're at StablySallitto.elderlaw.com. Our phone number is there. My email address is Elena, E-L-E-N-A, at staveleylaw.com, STAVELYLAW.com, and I should have put that under there. Email me, reference that you heard me tonight. You've got a follow-up question. I'm happy to answer it, because I know these are complicated issues, and I just want to say there's no right answer, there's no wrong answer. We just do the best we can with what we got and where we're going.
Elena, would you mind sending me your PowerPoint that I can send out to the folks who attended tonight?
Oh, sure, I'd be happy to.
Okay. There's one, let's see, a question came up. Do you review residence and care agreements? So
yes, residence agreements at like CCRCs or assisted livings, we do.
Yeah, I think, yeah.
Yeah, happy to review care agreements, and we write care agreements.
Okay, well, thank you, Elena, so much. That really was helpful.
Okay.
And thank you, everybody, for being here. If you feel like it was a lot of information, remember, probably next week, it's probably till about Tuesday next week that we get this up on the Anne Arundel County YouTube channel, as well as the Department of Aging website. So you'll be able to go back and flip through it. And, if there's something you missed that you want to check back on, you'll be able to do that. And again, thank you all for coming. If you would like to have a vital documents folder or the Maryland Advanced Directive, please feel free to email me. You all have the email from when I sent you the Zoom link. So feel free to give me an email and I'll get those out in the mail to you. Thank you again. Good night, everyone.
Good night. Thank you, Mary.